Often here at Gunderson, Denton, and Peterson, we'll have clients that will come in that they'll say, look, we started a business together, me and my partner here, and we started a business together a couple years ago, and here we are 2 years later, and things aren't going so well. Which is not uncommon. When people start a business together, they might be two friends that have known each other since high school, and they have a business idea, so they go into business together. And things typically tend to be kind of sunshine and rainbows at the beginning of the business, but even with the best of friends, what can occasionally happen is things go south. They start to have what start out as minor disagreements with how the business is run, how the money's being spent, what one business partner is doing the other one doesn't agree with. Those tend to build over time, and inevitably they'll come to us and say, look, I'm not happy with what the other partner's doing, and I need to know what I can do here. Can I drive them out of the business? Can I leave the business? If I leave the business, what do I need to do to leave the business? Can I just walk away? Am I going to be liable for anything that happens if the business continues to be run with this former partner of mine? What do I need to do to get out? Can I sell my interest to somebody else? These are legitimate questions that people have that frankly require some legal analysis that's pretty in-depth and shouldn't be just taken haphazardly. We here at Gunderson, Denton, and Peterson are familiar with these situations. We're familiar with the laws that govern limited liability companies, for example. They start with an analysis, frankly, of was there an operating agreement in place that governs the relationship of these two partners. It requires an in-depth look at that operating agreement. If there's not an operating agreement in place, then what statutes, or what we would call common law or case law, govern what this partner can do? Can you just walk away? Are you going to be liable? Do you need to file something, for example, with the Arizona Corporation Commission to actually remove yourself as a member of that business? It's not something that should be taken lightly and should be done with advice of legal counsel. Another situation that is akin to that occasionally happens is not when you just have two partners that have formed a business, but sometimes there'll be three friends, they form a business, which adds very different dynamics to that situation. You've got one partner now out of the three that says, I don't like what the other two are doing, I want to get out of the business, they're kind of ganging up on me a little bit. That one member is what we would often refer to as a minority interest holder. Let's say they hold 33%, the other two combined hold 66% of the business. What does that minority interest holder do? They're getting bullied by the other ones. They want out. They want to be bought out. Can they be bought out? How are they bought out? How is that value determined as far as what they should be paid to be bought out? Is there an operating agreement that addresses this type of situation, or are we now back to the default provisions that were put in place by the Arizona legislature with the statutes governing limited liability companies, or the case law or the common law? How does that impact this minority interest holder that just wants to get out and move on? Is this person going to be stuck in this business forever? Are they going to be liable for maybe the dumb things that these other two people are doing? Those are situations that are, again, legitimate questions. It's a very different dynamic when we're dealing with three members versus two members. And again, we here at Gunderson, Denton, and Peterson are familiar with these situations. We're familiar with the laws governing these situations, and we can advise this minority interest holder, or frankly the majority interest holders, as far as what they can do. Can the majority interest holders kick out that minority interest holder? Can they force a buyout? How do they close out the business if they all just can't agree on anything? These are fair questions that need to be addressed under the advice of counsel, which we're certainly capable of handling here at Gunderson, Denton, and Peterson. And these two scenarios, a scenario of where you have two partners that aren't getting along, or three that aren't getting along, are a testament to, or a classic problem scenario that arises when members of an LLC, or they are a testament to why members of an LLC should, at the beginning, cross their T's and dot their I's. Often what happens is these members, again, we're back in the honeymoon phase of building the business where it's sunshine and rainbows, and they don't think about doing an operating agreement. Sometimes they'll want to save money, which is certainly understandable, but you don't want to be penny wise and pound foolish by not spending the money on forming an operating agreement, thinking that it's going to be sunshine and rainbows forever. If you do, then you're going to be at the mercy of what the statutes say that were formed by the legislature that aren't specific to your needs when a problem does arise. the statutes maybe don't even address what the intent was of the parties to begin with. If you're not so concerned about saving that penny and being pound foolish down the road, it's wise to get an attorney at the beginning in this honeymoon phase to create an operating agreement that will address your needs, so that when these problems do arise, because situations, they just tend to, they do arise, you will be able to form an operating agreement that will address these situations and these questions in the way that you guys want it to be addressed, as opposed to just kind of being at the mercy of what the statutes do, which don't always help the members in these type of situations. We'd be happy to help you draft an operating agreement and get the business up and running, filing the proper paperwork with the Arizona Corporation Commission, and advising you as far as what your needs are, and we can articulate an operating agreement that is specific to your needs, because no two LLCs are the same with the same exact needs, and we're happy to help.